The federal government recently finalized a $1.8 billion payout, known as the Anti-Weaponization Fund. The controversy surrounding it is significant, as its broad eligibility rules allow for taxpayer dollars to reach individuals who physically assaulted police officers during the January 6th Capitol riot. The fund originates from a private lawsuit filed by the president against the Internal Revenue Service, an agency he was overseeing at the time. Justice Department lawyers chose to settle the suit rather than litigate it, creating a billion-dollar fund through an agreement reached entirely within the executive branch. That process has been halted. Within the space of a few hours, two separate federal judges issued rulings that froze the fund's operations and blocked all payouts. These rulings go beyond temporary delays. They target the legal foundation of the settlement agreement itself. Standard civil procedure dictates that once a lawsuit is mutually settled and dismissed, it is finalized. Usually, these agreements are insulated from further challenge or judicial review. A federal judge in Virginia has interrupted that finality by issuing an injunction. This order maintains the current status quo, legally barring the government from moving a single penny out of the fund. While the Virginia ruling stops the money, the Florida judge is reviewing the underlying settlement. She issued a direct order demanding legal justification for how a case between the president and his own administration could result in a valid settlement. Understanding why the fund is now at risk requires looking at the specific mechanics of collusive litigation and the standard for fraud on the court. Under the principle of standing, third parties cannot generally challenge a settlement unless they are directly injured by it. This often prevents outside groups from interfering in closed cases. However, a group of 35 retired federal judges successfully prompted a review of this case, despite having no direct personal stake in the outcome. They utilized the amicus curiae, or friend of the court brief, to bypass standing requirements and address the judge directly. The brief detailed rules allowing a judge to reopen a case unilaterally if there's evidence the court was given incomplete or misleading information. This converted the judges from outside observers into the catalyst for an internal judicial inquiry. The U.S. legal system is built on the requirement of a case or controversy. A valid lawsuit requires two parties with genuinely opposing interests. In a typical case, the truth is tested through adversarial friction, with a neutral arbiter weighing the competing arguments. Collusive litigation occurs when that friction disappears, because both sides actually want the same result. In this instance, the plaintiff was suing an agency he controlled. The retired judges argue the two sides stopped resisting each other and instead cooperated to secure a predetermined outcome. They identified two primary red flags. The $1.8 billion settlement amount was unprecedented for the type of claim involved, and the actual injury to the plaintiffs remained unclear. If a party essentially sues and settles with themselves using public money, the resulting agreement lacks the adversarial foundation required by law. This leads to the standard of fraud on the court. This is invoked when a judge believes the adversarial nature of a case was fictitious or that the court was actively misled. The Florida judge has now given the administration a 2-week deadline to present evidence that the lawsuit involved a genuine legal conflict. With this order, the burden of proof has shifted. The government must now affirmatively prove the settlement was legitimate to prevent the case from being reopened. The administration is now required to defend the integrity of the settlement under the immediate threat of a formal fraud inquiry. Reports suggest political aides are considering killing the fund in exchange for legislative deals, hoping this will make the judicial scrutiny disappear. But voluntarily abandoning the fund now does not erase the legal consequences if a fraud was already committed against the court during the settlement process. If the judge finds the court was misled, she can authorize discovery, forcing disclosure of internal documents showing exactly how the case was handled. This could lead to severe monetary or procedural penalties for the individuals and agencies involved. The mechanism triggered by the amicus brief has created a procedural reality that the administration cannot simply bypass by withdrawing the fund. Lawsuits between the executive branch and its own agencies test the limits of our legal system. When the usual adversarial checks fail, the court must rely on its own authority to ensure the judicial process isn't being used as a tool for internal executive agreements. The recent injunctions function as a systemic check, designed to halt a process that appears to bypass traditional legal friction. Procedural tools like amicus interventions and fraud standards serve as a check against settlements that are funded by the public but resolved without the transparency of a true courtroom struggle.